Here's a fun one. What happens when a district official censors a student's article for the high school newspaper because they don't like what it says?
Well, I can tell you, I would say that some people would consider that viewpoint discrimination, Chris. But I've been doing this sort of thing for a few years now, so
yeah,
that's my guess.
You would think that, and you would be right.
Hey!
Spoiler alert, I guess.
Yeah, so today on Chalk and Gavel, we're going to talk about a pretty interesting case from about 20 years ago that pit a high school student journalist against her school district in a fight over free speech and censorship. When the school didn't like how Katy Dean reported on a lawsuit against the district, officials shut it down. This is the case of Dean versus Utica Community Schools. Welcome to Chalk and Gavel, everybody, where we explore how the law shapes education one case at a time. I'm Jamie Cudlitz, a former middle school math teacher and principal.
And I'm Chris Thomas. I've been a high school English teacher and a school attorney. Now we're both professors of educational leadership, bringing you the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
All right, Jamie, I think you have our bell ringer?
I do. So all of this has kind of taken place, around December, beginning of January kind of thing. And I thought that this was a good example of how unsettled this area of law is. So I'm going to talk a little bit about a case out of California, Mirabelli versus Bonta.
Oh, yeah, I've been following this.
Yeah. So here's the short version. So California issued guidance telling schools that staff generally should not disclose a student's gender identity or, transition, any of that kind of stuff to parents without the student's permission.
Okay, right. So protecting the student's privacy rights.
Yes.
Right.
And saying, teachers, you don't have to tell parents.
Okay. And I'm
so,
sure parents accepted that.
Yeah, some did not.
Of course.
But most districts adopted policies that aligned with that guidance because, again, that's kind of what districts are supposed to do, is make their policies align with state guidance, laws, regulations, or whatever kind of works up that hierarchy, right?
Yeah.
But a lot of parents didn't like that, so and some teachers didn't like that.
Oh, so I'm sure some teachers were like, don't tie my hands like that, right?
Yeah, exactly. Yeah. So there was a lawsuit arguing that those policies violated parents' constitutional rights to direct the upbringing of their kid. So this is probably all sounding pretty familiar to you because this kind of stuff is playing out all over the country.
Right. And we've talked about parental rights in
Absolutely.
This context of like LGBT students' rights and kind of
and we talked
conflict.
about that. Yeah, we talked about that case from out of Florida and
right.
like we've talked about this stuff a lot. And so, I wanted to talk a little bit about this in the bell ringer because it's recent and it's an example of how these courts are just really wrestling with this unsettled area of law.
Sure.
So they also argued that teachers' First Amendment rights were being violated here. Okay.
Right.
Claiming that those policies forced them to withhold or misrepresent information.
Sure. Right. And those claims are really interesting because one of the things we've talked about with employee First Amendment rights is that one of the first questions you ask is it pursuant to your official duties? And there's an argument there that talking to parents about students is part of your job. So the school can really kind of tell you what and how to say it. So
exactly. Right.
I think the parents' rights claim feels stronger to me.
Yes.
But I don't know. I wasn't the court.
So, so in late December, right before Christmas, a federal district judge sided with the challengers and issued a sweeping injunction. The judge said the policies created a zone of secrecy around students. Okay. And he relied very heavily on which court decision do you think?
I mean, I'm thinking West Virginia v. Barnett. No.
Think more recent.
Oh. Oh no. What? It's got too many consonants in a row.
No, we've covered it very extensively.
It probably wasn't Mahmoud.
It was Mahmoud.
Oh yeah. I was thinking it was the gender affirming care case, which I forget the name of.
I don't know if that one came up.
Okay. But yeah, anyway, I mean, Mahmoud, parental rights, right? We're talking about parental rights.
Yeah.
Though this isn't opting out, right? Like this feels different because this is an affirmative thing. That feels different.
Yeah. But he referenced Mahmoud, also ruled that teachers have free speech and religious freedom rights to communicate with parents about students' gender issues.
Sure.
Sweeping injunction. Right?
But does that mean that it's not part of their jobs?
I think he was more focused on less on that and more on their religious rights and free speech rights and things like that. Doesn't matter because it didn't last very long. So,
okay. But wait, there's more.
Wait. So that California appealed the decision, and recently, like at the beginning of January, a unanimous 3-judge panel
of the Ninth Circuit,
blocked that injunction.
Okay.
So the appeals court said that the district court likely went too far in expanding parental rights.
Okay. Right. Which did they pick up that opt out versus like affirmative right kind of thing? Or
I didn't catch that as much as it was about the injunction being overly broad and vague and confusing and things like the public interest should favor protecting students and giving schools clearer guidance on how to do so while the case kind of percolates.
Right. And that's usually the argument for these kinds of rules about like not necessarily outing kids to their parents if their parents don't recognize that or what have you. Like one of the arguments is that like, well, we want to make sure that we're respecting these kids' interests and protecting them.
Yeah.
But that's not, I doubt that's true in every case.
Yeah. Yeah. And so I think, the big takeaway with what's happening here is we've got this back and forth going on between, students' privacy rights and parents' rights and, what role the school plays and all of this back and forth.
And schools are just kind of caught in the middle of that.
Pretty much. Right. And because those particular questions or those legal questions are playing out in the courts right now, and schools just want guidance, right? Like, just tell us. Of course, you're going to stand on one side of this issue or the other. But at the end of the day, once all of this stuff is settled and your schools give you guidance that is in alignment with the law, like you need to follow it.
Right.
Right. And the big takeaway as of right now in California is that their guidance is back into effect right now. But I think, I think where all this has landed, this particular case has landed is it reinforces how unsettled this law is, right? And the appeals court, to me, sounded like they were saying to the district court, hold your horses, right? We haven't settled all of this yet. We've got to let this play out in the court system. You went a little too far. Let's slow this thing down, and figure this out. Let the system figure it out, right?
Right.
That was sort of my interpretation.
Yeah, and like letting these issues percolate is a big piece of the way our judicial system is set up is to air the stuff so that we can get like a full hearing and like everyone can make the arguments they want to make.
Right.
That issue about like how unsettled this is, the big challenge for me as I'm thinking about this is like, you've got kind of these 3 groups. You've got students, schools, and parents, and all of them have rules and protections and rights.
Mm-hmm.
And it's a conflict of rights in a lot of ways. And that is really challenging because, during the Biden presidency, we had a lot of protections for LGBTQ students. Like those were being, championed, and a lot of schools, in the last decade or so have been taking those on. And so, there's an argument there that like Title IX under the new old regs, the old new regs, wherever we are, like required you to protect transgender students. And so like, schools were being pushed in that direction by policy changes, but now we've got this parental rights movement with things like Mahmoud and other parental rights laws. And so like, it's kind of a shifting sand sea change kind of thing where like schools are just kind of caught in the middle of like potentially conflicting legal responsibilities. And until a court tells them where to navigate, there's always going to be uncertainty, and, schools are doing their best to navigate that.
Yeah. And, and listen, we talked about it in the last episode with the Becky Pepper Jackson case and everything. Like there's a lot of unsettled issues, legally speaking, percolating right now, but that's what we're here for, folks. We're here to tell you all about them.
Yeah. So we're going to tell you about all the new unsettled stuff. So let's talk about a case from 20 years ago.
Yeah. And it's pretty much settled. Or the law is relatively settled on this, or
relatively. Yeah.
I would say, look, these cases are very important, even when the law seems settled, because as we've seen in the last 10 years, we thought a lot of stuff was settled, but it's not.
Right. Well, and there's a question of like, what does the law mean in practice, right? And so like this, I think, has some really interesting implications, for practice and for how we organize school newspapers or student first free speech. So like, it might be, the facts might be 20 years old, but this is a very relevant case.
Totally. And I think that these stories, and this is one of the reasons why we do this podcast and we cover a lot of old cases too, is because the stories are real and they're relevant to current students, to current teachers, to current administrators, and they help us understand these, the nuances of these kinds of situations. And I'm sure that many of you educators out there who are listening to this podcast and have listened to this podcast have listened to a lot of the stories and have thought of like, oh, that reminds me of a situation that, I experienced or that I saw in my school. Right. So that's why that
comes up all the time when I'm teaching school law.
Oh yeah.
Everyone has a story.
Oh
right.
Yeah.
And
yeah. So you ready?
Ready.
Okay. So today our case comes from the Utica Community Schools, which is near Detroit. And the story starts in 2002 during a staff meeting for The Arrow. Okay. The Arrow, Chris, is a student-led school newspaper for Utica High School.
That's a pretty cool name for a newspaper.
I think so.
Right?
Yeah.
Like we're aiming straight at the truth.
Oh, nice.
Bullseye for truth. Like there's a lot of things you could do with archery imagery.
I think you're pretty on target. Okay. So like a lot of school sponsored newspapers, The Arrow was completely run by a group of students. Okay. There were about 20 of them, and students were the editors. They were the reporters. They were the publicists. They were the fundraisers. They were the publishers. You get the idea. Students did everything. Okay. Interestingly, The Arrow was funded by the sale of advertising to local businesses, which was also all handled by the students, right? Like they were the fundraisers too.
Yeah. Okay. So like the school isn't necessarily paying for, I'm sure like the space and like a faculty advisor or whatever, but like the actual publishing. Interesting. Okay.
Yeah. It's almost like, okay, this is a school associated publication. I don't even know if I would call it school sponsored, at least in terms of financially, right? It sounds like it was funded by outside businesses. Anyway.
Well, they get course credit for doing it, I assume.
Oh, so, yeah. So there's that.
Right.
Piece.
Yeah.
So The only staff member involved was the faculty advisor. Her name was Gloria Ullman. And she was a journalism teacher at the school. And she also taught graduate level journalism classes at Michigan State and Oakland universities.
Okay. Sounds like she knows what she's doing.
Seems like it.
Yeah.
So in her role, she would offer advice on what stories to run. She would review, she would criticize, she would edit. She was involved. Okay. And
Sure.
as I would think a journalism expert who is the faculty mentor should probably be involved.
Right.
Other than that, there had never been any oversight by anybody at the district over what the Arrow could or couldn't publish.
I'm going to go out on a limb and say until now.
Yep, exactly. But that's why I mention it. That's an important piece.
Right. This is a deviation from practice.
Exactly. So at that staff meeting in 2002, one of the staff members, Dan, suggested that they run a story about a lawsuit that was pending against the district. Okay. Interesting. The lawsuit involved two residents, Joanne and Ray Francis, who lived near the district's bus garage. They were suing the district, claiming that the fumes from the buses constituted a nuance. Constituted.
I'm sure there's a lot of nuance.
Yeah, there could be. Constituted a nuisance and violated their right of privacy and harmed their health. Privacy, I don't know about, but like harming health, that sounds like a potentially reasonable claim.
Yeah, I mean, it's a tort claim. So yeah.
So anyway, lawsuit pending. The students agreed to run the story. The topic had come up at a school board meeting. There was already some coverage from a local newspaper. The school's athletic fields were also close to the bus depot, so the students felt like it was an issue of concern for that school's community.
Right. Yeah. If the fumes are making the people who live there sick, and you've got all these student athletes running up and down a field, okay. I could see why you would run it.
I had a very close friend who I've spoken about on this show before, who would misquote a lot of those, like malapropisms or whatever it's
idioms or whatever.
Yeah. And he would say he sat in the back of a boat once near the engine, and he said, "These fumes are making me obnoxious." God, I love that guy. Okay. Anyway, that's what this case has reminded me of.
That's really good. I like that.
Okay. So, so Dan and another student, Katy Dean, all right, they go out, they pound the pavement, journalistic term there, right? Isn't that a German? I think it is.
Sounds like it.
They go out pounding the pavement, and they start doing some hard-hitting investigative journalism.
Look at you.
Yeah, look at that. So in February of 2002, they reviewed the school board meeting minutes where Mrs. Francis, the community member, spoke about the diesel fume problem.
Okay.
They interviewed the Francises at their home for approximately 3 to 4 hours.
That's a long interview.
That is a long interview. And Katy, on the advice of the journalism advisor, reached out to the district for comment. Okay.
Yeah, as you do, right?
As you do. Let's try to get both sides. So this, unfortunately, is where things start to fall apart. Katy attempted to interview the district officials by reaching out to the superintendent and the district's transportation department. She got a hold of folks, but they all refused to comment and referred her to the district's director of community relations. That sounds appropriate.
Pretty standard.
It's pending litigation, and, we want to be careful about what we say.
Mm-hmm.
This is good advice for all of you out there right now. If something's going on, especially if the law is involved, if there's a lawsuit involved and somebody asks you for comment, you better make sure that it's going through the proper channels so that you don't say the wrong thing to the wrong person and jeopardize the lawsuit somehow.
Right. Yeah. There needs to be a single voice with a coherent story.
Yes, exactly. So Katy spoke to that communications relation person 2 or 3 times, but was ultimately told that there would be no comment from the district. Okay.
Okay.
And they said it was their policy not to comment on pending litigation, which is a pretty standard response, right?
Yeah, that makes sense. I mean, yeah, that's a pretty standard response. I would think, you could also do something where it's like, we're aware of the lawsuit. I don't know how like empathetic you want to get about like, we feel for the Francises.
Right.
Situation.
But that's what a communications person is for, is right. Like, how finely can we walk that line?
Right. Like, we feel sorry for them. We feel bad for them, but also we had nothing to do with it.
Right. Or, we're, our legal team is working to resolve this situation in a way that works out,
well,
properly.
that sounds like, yeah.
But my point is like you want to try to walk a fine line with that, as opposed to saying, we're not talking.
Right. Well, and there's a range of options there, right? Like there's no, we can't comment because it's our policy not to comment. Like, yeah, I mean, that's a valid response. You could have done another response. Like there's nothing about a lawsuit that says like, hey, you can't talk about this thing.
No,
but,
exactly.
Different lawyers have different opinions about that.
Right. Now, that didn't really completely satisfy Katy.
I can imagine.
And she's a hard-hitting journalist here, apparently.
Turn over every stone.
Yeah, exactly. Leaf? I don't know. Stone.
What do you turn over?
Yeah, well, anything. You can turn over anything. Most things, right? So, while the district declined to comment, Katy she did her due diligence. She followed up with the superintendent's office several times to try to verify any details and quotes provided by the Francises.
Oh.
Yeah, the superintendent, the community relations official, did not return any of Katy's calls and didn't make any further comments. So communications relations person said to Katy, district has no comment. Katy repeatedly tried to say, can you verify this? Can you respond to that statement? Can you do whatever? And they just never returned any calls.
Okay. So like at this point, like we're in February, like they know what is in the article because Katy gave them a chance to like respond to specific quotes and things and different facts or like allegations or whatever it might be. Like, so like, I guess the content of the article shouldn't be a surprise then.
Doesn't seem like it's going to be. Katy talked to as many people. It seems like Katy talked to as many people as she could. She talked to the high school's principal.
Oh, she even talked to the principal?
She talked to the principal. The principal said, that he didn't know anything about the case.
Sure. Why would he?
Well, exactly. It has nothing. It really has nothing to do with him. It's the district's bus depot, right?
Right.
Like this is all district level stuff. The school just happens to be located close to it. But he did say to Katy that he thought it was an interesting case to cover.
Oh, okay.
So
that's encouraging.
I mean, I would agree personally, given what I know of the situation, which pretty much only comes from this court opinion, but whatever. So Katy took all that information. She wrote up the story based on all of what she had collected, along with her own internal research into the health effects of diesel exhaust. Okay.
Oh, okay.
She sounds
thorough.
like extensively researched article here. Especially for, this is high school.
For a high school journalist.
Paper, right?
Yeah.
So she submitted her early drafts to the journalism advisor, and a day before the article was to go to print, March 6th, the story was almost done. The newspaper goes to print on the 7th, and it's published on the 15th. That's the timeline, okay? About a week after it goes to print, it goes out.
That's awesome. That's quick.
Yeah, it is. The story's ready to go. Folks at the district have known about this article, like you said, Chris, since at least February when Katy was doing trying to get all of the comments and all that stuff. Everything's fine, right? Like we're ready to go.
Right, yeah. If there had been an issue, I imagine someone would have said something already.
Well, they didn't, but they're going to now.
Oh, okay, good.
So on March 6th, the journalism advisor went to the principal. She mentioned that the students were doing the bus garage litigation story, and she asked for a response from the district on the issue. Like everyone else, the principal referred the advisor to the director of community relations.
Good. I like that instinct. Everyone's got a good instinct there.
Exactly. Also, on the 6th, the principal got a copy of the draft of the story. Okay.
Okay.
Now, the record here doesn't say how he got it, but I'm assuming that Ullman, the journalism advisor, I'm assuming she gave it to him as part of the sort of due diligence in getting a comment. Here's the article we're planning on releasing.
Does the district want to add a comment? Right.
Yeah, exactly.
Yeah. That seems plausible.
Yeah. So later on, in the lawsuit, the principal said that he had some concerns about the article based on the use of pseudonyms. The draft didn't use the Francis's names, though the final article did, and some potentially unreliable sources that Katy had cited to USA Today for scientific data on the effects of diesel fumes. So the principal's kind of later on saying, maybe there was some stuff in this thing that was,
That feels flimsy.
Yes, it does. His comment on what's flimsy about the article seems flimsy.
Right. Yeah. We got layers of flimsiness here.
Yeah. So, apparently because of those concerns, the principal forwarded the draft to his boss, the assistant superintendent, who forwarded it to his boss, the superintendent.
Oh, right. So this goes up the ladder.
This has gone up the proverbial ladder. Yes.
Okay.
The superintendent then told the assistant superintendent that she believed the story contained a number of, quote, inaccuracies that they had the option to respond to before, but
maybe they didn't read that email.
Yeah. According to the superintendent's later testimony, she felt that the inference that the district had anything to do with the Francis's health concerns, unfortunately, the husband tragically ended up dying of lung cancer in July of 2002. So just a few months after all of this.
Oh my gosh. Okay. So that explains the lawsuits then and why this is so serious.
Exactly.
Okay.
It definitely doesn't feel like the Francises were just saying, let's just complain for the sake of complaining.
I don't like the diesel smell.
Yeah.
Right?
It sounds like it, potentially was a major thing, right?
Sure. Yeah. Okay. And I can see the district's concern then, because that there's potential some heavy legal consequences there.
Totally. But I'm sure that the district is looking at this article now saying, well, this ain't helping us.
Right. Well, they also didn't help themselves.
Well,
they had a chance to comment and respond to stuff.
You're getting ahead of things, Chris.
Okay.
Anyway, she felt that the inference that the district had anything to do with all of those health situations was inaccurate based on environmental studies of the district that the district had conducted for the litigation. So,
oh wow, okay. So that lawsuit is pretty far along. If you've got if you've done doing
environmental studies and things like that, but again, there was no way for Katy to know that. She asked if there was any information, but nobody told her. And I'm not necessarily faulting the district for not telling her. But I might have, and I don't know. I also don't know if the community relations person was in dialogue with the school's attorneys about the fact that the school journalists are essentially soliciting information. Is there anything that we can share or cannot share?
Right.
And
you probably wouldn't share that,
might not
during litigation, because that's a big part of litigation strategy.
Yeah. Don't show all your cards. Right.
Well, you have to for discovery requests and stuff like that, but
but they weren't there yet. It didn't seem like they were there yet, right? That information might not have been out.
Right.
Anyway, move ahead to the next day, March 7th. That's when it's supposed to go to print, right?
Right.
The superintendent, the assistant superintendent, they review the draft of the article together, and after a phone call with the district's attorney, the superintendent decides that the story would not be printed.
Yay! They called the attorney.
But I don't know what the attorney advised him, but whatever that conversation was resulted in the superintendent saying, you're not going to publish that.
Yeah. I mean, attorneys aren't always we don't have magic balls, right? We can't look into the future and see how a court is going to decide things.
Right.
But, I applaud the instinct. Hey, this has potential legal implications here. Let's call the attorney.
Now, for all we know, the attorney could have said, you're on thin ice.
But here's the best argument we've got. If you want to, go ahead.
If you want to take the chance. Yeah, but you're taking a risk that this is violating First Amendment, or who knows? The school attorney would have said that's going to really screw this lawsuit up. So don't, the
lesser of two evils.
Yeah. So who knows what that conversation was, but whatever it was, it resulted in the superintendent saying, let's kill the story.
Okay.
So the superintendent didn't do it. She told the assistant superintendent to do it.
Okay.
So the assistant superintendent contacted the principal. The principal called the journalism advisor and told her to remove the article. The advisor objected.
Sure. So we went up the ladder and then we went down.
And now we're going back down.
All right. This is like my least favorite thing about bureaucracy, where it's like, I can't make a decision, so I'm going to kick it up. And then they made a decision, but they're not going to like enforce the decision. They're going to kick that down for me.
Yes, exactly.
Yeah. There's a better way to do that, I think.
So, so the journalism advisor did not think that was a good idea and asked to know why the story was being killed. And the only explanation provided at that time was that it was inappropriate for the paper to run an article specific to the litigation.
That feels defensible because that isn't about the content of the article, right?
It's about that's pending litigation.
Right. Yeah. So it's anything about pending litigation. So it's just like, hey, don't talk about this subset of things. It's not about, what you say or how you say it.
Right.
But, because this is a school newspaper, we've got Hazelwood in the background, the Supreme Court case about student journalism, which talks about whether or not you have a valid pedagogical concern. And that doesn't sound like a pedagogical concern. That sounds like a business concern.
Exactly. As far as Hazelwood is concerned, we're in some different waters slightly.
Right.
It's not the end of the story. The article was not published, by the way.
Okay. So they did pull the article.
They pulled the article, but it was published in a local paper. So whoever it was, the student journalists or whatever, Katy,
right. Somebody said,
you're not running it. I'm going to find somebody who will. So she took it to another paper and then they published it. I think it was the Macomb Daily was the,
okay.
Was
right.
The
so the censorship was obviously effective then, right? Hey, don't run this story. And then it gets run by, I assume, a paper with a larger circulation. So what is the Streisand effect, right? Where you try to hide something, and by doing so, you actually draw more attention to it. So
yes.
I think there's a lesson there about hey, trying to suppress something, it's just going to blow up in your face potentially.
Yeah. Well, so speaking of blowing up in your face, what happened next, Chris?
I thought you'd never ask. Katy filed a lawsuit.
Oh, so now there's lots of lawsuits happening.
Right. So now instead of one, you have two.
You have two for the price of one. Well, it's going to be for the price of two, but that's okay.
Right. Yeah. Who knows? So Katy sues in federal court, arguing that her First Amendment rights to freedom of speech had been violated when the district censored her article.
Oh, okay.
So she sought declaratory relief, which is basically just a statement saying, yes, your rights have been violated. And she sought an injunction to compel the district to publish her story.
Even though it had already been published?
Yeah, because it hadn't been published in the Arrow.
Oh, okay.
Yeah.
Okay.
And as part of that, I think this is the real kicker, she wanted it published in the Arrow along with a statement explaining that it had been unconstitutionally censored.
Ah, wow. Wow. You know what? If you're going to go big,
right.
Go big. Go big or go home.
This is 1,000,000% about vindicating her First Amendment rights, and I am here for it. So after discovery, both Katy and the district file cross motions for summary judgment.
Okay, so that basically means saying, you know what, even if you take their facts, the other side's facts at face value, I still win as a matter of law. And then the other side was saying the same thing.
Right. Yeah. Right? There's no disagreement here about the facts.
Right.
And even if you draw all inferences in their favor, I win. And the other side saying no, if you draw all inferences in their favor, I win.
Yeah.
And so, no need to go to trial here. we all agree on the facts on what happened. The only disagreement is on how the law applies to the facts. What did the court do? Spoiler alert, another one. I'm going to give you the very first sentence of the court's opinion, and I think this gives away the game. So this is a quote from President Truman that the court starts its opinion with. You ready?
Yeah.
The court starts with, once a government is committed to the principle of silencing the voice of opposition, it has only one way to go, and that is down the path of increasingly repressive measures until it becomes a source of terror to all its citizens and creates a country where everyone lives in fear.
Wow. Did not mince words there.
No, I think we know where the judge stands.
Ha.
Yeah. So, pretty. You could probably guess which way this is all going.
Oh, yeah.
So the court is really serious about the value of independent journalism from government interference. Schools, this is a public school. It's a governmental actor.
Mm-hmm. Mm-hmm.
Court doesn't seem convinced at all that like student journalists should be treated differently. Like there's very little concern here that these are students. It's still journalism. So the court is full on in, respecting the institution of journalism in a democratic society.
Yeah. 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 Wow.
Yeah. So like, I when I picked up this this case and read that first one, I was like, I'm gonna like this guy.
Yeah.
So let's dig into that First Amendment claim.
Okay.
So, like most of these speech cases, it depends on what bucket we put this speech into. So different kinds of speech or different categories of speech in different contexts, like they all have different legal standards,
Right.
Which is why First Amendment law is so much fun. Or so, I don't know, what's the word I want? Difficult. That's not the right word, but so we've talked about a lot of these on the show. Tinker, Bethel versus Frazier, Morse v. Frederick.
Yeah. It's all speech, but it's all different kinds of speech.
Right. Is it pure student speech? Is it lewd and indecent speech? Is it speech that
political
reasonably promotes
speech?
illegal drug use?
Yeah.
Right.
Political speech. Or like this.
Right.
And
where did you say it? What's the forum? Right.
Yeah.
All of those are different analyses.
Exactly. Yeah.
Mm-hmm.
Yeah.
But there's one we haven't covered yet.
Ooh.
We've talked about it a little bit.
Yeah.
When we talked about curriculum and student coursework, but that's Hazelwood.
Yeah.
So Hazelwood covers, quote, school-sponsored speech. Right. And that is speech that the school either affirmatively promotes, so speech that the school affirmatively promotes, or speech that is like commingled between the school and the student, where like, the line that the court uses, it bears the school's imprimatur. Basically, like somebody looking at that would be like, oh, is that the school talking or is that the student talking? So under Hazelwood, schools can exercise control over the school-sponsored speech as long as their actions are, here's the standard, quote, reasonably related to a legitimate pedagogical concern. Right. So basically, if the school is promoting the speech and the speech commingles student speech with the school's speech or resources, the school can control the speech as long as they're doing so for a valid educational reason.
Right. So in other words, if you don't like what the speech is, if you don't agree with the idea, that's not a good enough reason.
Right.
There's got to be an educational reason. Like, for example, if Katy, and, I'm only speculating here how, this could have gone a different way, but if Katy had done really horrible reporting and not tried to get both sides or really tried to create a bias article that sort of maybe she went against the advice of the advisor about how to do, then that starts working its way
You're trying
into,
to teach her something. You're trying to teach her to do better journalism, right?
Yeah, exactly. Yeah. So educationally speaking, that's not a good, a good approach to writing
and you
an
could,
article.
Like, other valid educational concerns, like, the school community, protecting other students, journalistic standards are absolutely another one. So like, there's lots of valid educational concerns here, or potential educational concerns here, because did the school have valid educational reasons for doing what it did?
Well, I think, given that background on Hazelwood and that kind of, pedagogical standard, the answer to that question is No.
Yeah. And that's what the court says too, right? Like the school is trying to argue that, there were privacy concerns, that the article was biased and didn't align with journalistic standards.
Mm-hmm.
It lacked credible sources, and it was inaccurate. So those are all the school's arguments. And the court says no to all of them, slaps them down. So first, like, there's no privacy concerns. This is all public information.
Right.
Like, it's already been reported in the local newspaper before the students even ran the article or started writing the article. So there's really no privacy concerns here.
Right.
Second, there's not really bias. Like, this is, if the article only tells one side of the story, that's because the district refused to comment. So, like, that's not on Katy.
And that happens all the time in journalism.
And the article just reports what other people said. Like, Katy doesn't make any claims. She kind of just, like, lays out, like, this is what this person said. Or, the science is mixed on whether or not diesel fumes cause cancer. So, like, it's very much reporting. It's not purporting to take a side. Right. And the important thing here is Katy actually had two expert witnesses on her side who testified that the article aligned with journalistic standards and was well written and balanced. So she's got these two experts who are both themselves like collegiate journalism professors who are saying, like, look, this is a really good article. I think one of them even said, like, this is a good article, period. Not a good student article. Like, this is
just a
legit
journalism. Yeah.
Yeah. Right. And so, like, you've got two experts saying that, and then the school didn't put forth an expert witness to say, like, hey, there were concerns here. They just had the superintendent and, whoever testified that, like, yeah, we were worried about these educational things. Putting aside the fact that that's not what they said when they were doing this all, which begs the question whether or not that was their actual motivation or not.
Yeah. I mean, like, they were like, we're not going to comment on pending litigation.
Right.
They didn't make any statements to anybody saying we have concerns about educationally about the content of this article.
Not at the time. Right.
Right.
Yeah.
And it's probably because they didn't have any at the time. It's a guess. I'm guessing.
Potentially. Like, it raises the question of, like, whether or not these are pretextual justifications.
Yes, exactly.
Right.
Yeah.
So the last thing that the school argues is this idea of inaccuracies. And so the superintendent testified during the litigation that, there were a number of inaccuracies in the article, including, like, allegations that the district's bus fumes caused the Francis's medical concerns. There was hearsay from the residents about the district's responsibility for all of this. There were statements from one of the Francises that the superintendent had visited their home, which the superintendent said was false. And so the court looks at all of these things that the superintendent is saying is inaccurate. And the court just kind of looks at this as, like, that's not inaccuracies with the reporting. That's your disagreement with the underlying allegations of the lawsuit. Yeah. So, like, you're not upset about what was reported. You're upset about, like, you just disagree with the allegations that they're making that were balanced, like, were reported in a balanced way.
Yeah. Like, the reporting has nothing to do with that. The reporting is just reporting on what those things were.
Right. Yeah.
Right?
Yeah. Katy's just reporting other people's perspectives.
Right.
Yeah. And so instead, what the court says is, like, this isn't you objecting to inaccuracies. This is you, school, engaging in viewpoint discrimination. Because that's what we've got here. Like, the district just fundamentally disagreed with the views expressed by the Francises that was reported in the article.
Right.
And we've talked about it before, but the First Amendment really doesn't like viewpoint discrimination by governmental figures. The government can't censor one opinion on a topic and allow the opposite opinion. That's a huge no-no.
Yeah.
And so, according to the court, like, viewpoint discrimination by school officials is itself enough to override whether or not there was a legitimate pedagogical concern. So even if there was a plausible, valid educational interest, if you can show viewpoint discrimination as a student, the student will win.
That trumps everything.
Like, we hate viewpoint discrimination that much that it essentially trumps Hazelwood.
Yeah. Wow.
So it overrides Hazelwood, or maybe it's like a step 0 to Hazelwood.
I mean, that's a good thing to think about, everybody. Like, you might disagree with the ideas in an article, but if you also have pedagogical concerns about it, you better make darn sure that your disagreement with the ideas in there not in any way a
Right.
factor that would compel you to,
Right.
censor the speech. Right?
Yeah. So like if you publish an article that like advocates for abstinence only, just as an example,
Mhm.
like that's a viewpoint.
That is
And
a
so
viewpoint.
if you decline to run an article on like, teenage sexuality, like now you're running some interesting ground where now you've got
Right.
some viewpoint discrimination.
But I
potentially.
will say, on using that,
Potentially valid educational concerns.
right? Like if this
Right.
was an elementary school newspaper doing a story on abstinence,
right.
like you could probably have a much
Why
better
would they
case
do that?
for pedagogically, this is not an appropriate
Right,
article
right.
for this paper
Right.
versus, in
But
high school.
but according to this court, even if there's a valid educational concern, if you're engaging in viewpoint discrimination,
Yep.
the district loses.
Yep.
So like, it's a obviously like there's other, maybe my example wasn't very good, but like, it's tricky, right? Because like we've added another layer to Hazelwood.
Right.
But, here it doesn't matter because we don't have valid educational concerns and we also have viewpoint discrimination. So I guess the
even if we
district
did
loses-
have valid educational concerns,
Right,
it doesn't
yeah.
matter.
Yeah, the district loses twice.
Yeah. Yeah. Whoops.
But do you want to know one thing that kind of just blew my mind in this whole case?
Yes.
I was hoping you'd say yes. I don't know what I would do if you said no. So in oral argument for this case, and it's in the court's opinion, an attorney for the school district conceded that the school would not have censored the article if it had explicitly taken the district's side in the litigation. I know.
What?
They admitted to
admitted
viewpoint
that it was
discrimination
viewpoint
on the
discrimination.
record. Like, hey, if you had told the other view, we wouldn't have stopped it.
Wait, who
So,
did
like,
you say said that? An
One of
attorney?
the attorneys for the and I'm sure it was a back and forth with the judge where the judge is like, look,
Yeah,
would you have
asking-
run the story if it
Yeah.
had done this? And you as the attorney, you've got to find a different way to answer that question. I don't care if the answer
Totally.
is actually yes, like just don't answer the question, answer a different question, like do something different. Like, obviously
and-
honesty and documenting all this stuff is really, really important, but don't write down or say something that
That's
you're
gonna-
doing something for an illegal reason, right? Like,
Yeah.
I mean, don't do things for illegal reasons. That's step number one.
Yeah.
But like, maybe don't tell the court you did it for an illegal reason.
Yeah, wow. That's crazy. But
Yeah.
I will say, like, that does happen a lot, in back and forths between, in that kind of dialogue. Like, okay, so let's take apart your argument here. Does,
Right.
that happens, especially at the Supreme Court. Like, that's kind of how the arguments run at the
Right.
Supreme Court is like, you get your 2 minutes to give your case. And then the rest of the time is usually this rapid fire back and forth between the justices and the attorney saying, okay, well, the premise of your argument is this. Are you saying that this is true or this? And it's so rapid fire that you could find yourself kind of backed into a corner.
Right. And I think that's exactly what happened where the judge just got this attorney into a corner where like they basically either had to say like, yes, we would have blocked it anyway.
Yeah.
And then that would have completely undercut their inaccuracies argument, right? Like,
Yes.
so like, it's
Whoops.
probably less of a concern with the attorney and more just a really good judge who was able to just kind of like really stick like,
Well, it dig down to the heart of
Right.
what was going on. Like, exactly. And that's,
Right.
that's what should happen. Like, you're making an argument. That's what these cases are all about, right?
Right.
You are trying to craft an argument that looks most favorable for your side, right?
And the judge's job is to
take
figure
it
out
apart and
which
figure
one
out
is
where the
right.
holes are, right?
Yeah, And I think the judge did that.
yeah, exactly. That's wow.
Yeah.
Very interesting. So, big takeaways here. Don't viewpoint discriminate.
Yeah, that's a good one. It kind of goes back to that. I mean, the Streisand effect, I think, is a huge one where like, even if you do try to censor it, like that's going to be, it's going to draw more attention to the thing you're trying to censor.
Right.
And, we've said it before that like the remedy for speech you don't like is speech you do like. So instead
more
of trying to
speech.
stop speech, maybe more speech is the approach.
Yeah.
For me, I think there's an opportunity here for like thinking about being proactive versus reactive. Because the school officials knew about this article for weeks before they canned it.
Yeah. So as an attorney, Chris, like if you were advising a school district through this process, and let's say a superintendent came to you and said, we just got news that the student newspaper is going to do a story on this litigation that we're facing. And they're coming to me for comments. They're presenting information that they have uncovered and they want my response to it. What should I do? How should I respond to it? Like what kind of advice would you have given a school in this kind of situation?
I'm an attorney, but I'm not your attorney. But you know, in a situation like this, I'd probably say like, okay, well, you know, what's your concern here? Your concern is either that they're going to, you know, jeopardize our legal position. You know, I'm not necessarily worried about that because this is a student newspaper. It's not necessarily the school speaking. So there's no real concern there, at least, you know, me personally. I think it comes down to like, well, you know, if you're uncomfortable with that, like if we don't want to comment because you know, saying nothing is a safer route and a lot of attorneys are risk adverse, then, you know, we don't comment. But if you're more worried about them running the story because it's commenting on ongoing litigation, like talk to the journalists, like talk to them now, have a sit down before they get to the like writing stage and say like, hey, we have concerns about you running this story. We want to make sure like, you know, that we express our concerns and that we make sure that it's done in a way that, you know,
isn't going to jeopardize
our interests, right?
Yeah.
Yeah. And so there's an opportunity for a conversation there. And like, you know, maybe if you have that conversation, the school's like, or the students are like, hey, you know, maybe it doesn't make sense to run this down, but they got so far along the process where like, now it's you told me I can't do that.
Yeah. So you're kind of saying like, you know, look, let's have a dialogue and maybe this is a teachable moment. And if after that they still decide to run the story, maybe your advice as an attorney is, look, you know, the only thing I would advise you against is killing the story at this point. Because, you know, if you don't want to make any comment because you're afraid of how it's going to affect the lawsuit, then that's fine. But killing the story is potentially going to bring another lawsuit that you don't want to face. Right. So even if the story does make the school or the district look bad, it's better than jeopardizing the lawsuit or taking on a different lawsuit. Something like that, maybe?
Something like that. Or even just saying like, hey, ask them if they'll add, like, the district declined to comment. The district has denied any wrongdoing.
Oh, because that would be public knowledge anyway.
Right. Yeah. You know, we answered the lawsuit. We denied that we did it, I assume, or, you know, that we caused any harm.
Yeah.
That's kind of the direction I would go. But yeah, it's a tricky situation because you're dealing with.
Well, you're dealing with a lot. And the free speech thing is complicated in and of itself, right? Like as we've talked about. So
it is. Yeah.
This is a great story. I like this one. This is a good case.
I do too. Yeah. It's a fun one.
Well, let's just dive right into the homework. What do you think?
I thought you were going to do the homework first.
Oh, you want me to do the homework?
I mean, if you want to. Yeah, because you can come up with something funny.
I can. That's a lot of pressure, man.
I know.
Okay, everybody. So your homework is to fly straight and true like an arrow.
I see what you did there.
Yeah, thanks. To our website, chalkandgavel.com. Lots of fun stuff there, including great merch. And you can find you can sign up for our mailing list, all that stuff. We're going to keep you posted about how our live episode at South by Southwest goes. That's pretty awesome. I don't know if we've mentioned that on the show before, have we?
I think we have.
Yeah. So that's coming up in March.
Southwest EDU.
EDU.
We're not at the
We're not the big
one.
No, it's not the.
No, not yet.
Not yet. Yeah, so check us out, follow us on social media, and rate and review and like and subscribe and follow and all of those things. And we appreciate you tuning in to this fun little podcast that we got going on, and support the show if you can, because any little bit helps us keep this thing going. And that's about it for this week. So we'll see you again in 2 weeks, everybody. Have a good one.